welcome everyone. Thank you for joining us this evening. This is GLADlaw's fourth briefing since Election Day 2024, and it's been such a pleasure and really an honor to gather with folks in our community at pivotal moments as we confront the attacks on LGBTQ people coming from the federal administration, state politicians, and elsewhere around the country. GLADlaw remains committed to doing everything, absolutely everything we can to stop, delay, and reduce the harm of those attacks, and also to keep folks informed as the legal landscape changes. Today's briefing is specifically about the Supreme Court term that just wrapped up last week, and we're going to focus on three rulings with a significant impact on LGBTQ people: Scrimetti versus U.S., Kennedy versus Braidwood, Mahmoud v. Taylor. We received a number of questions online about the passport case, which we will try to get to and address towards the end of the call, but we're first going to cover the three cases that I just mentioned. With me on the panel today, I'm super excited, not only because I get to work with them every single day, but because I get to learn from them. Here today is GLADlaw Senior Director of Transgender and Queer Rights, Jennifer Levi, Senior Director of Litigation and HIV Law, Ben Klein, and Senior Advisor and held many other titles here at GLADlaw, Gary Busick. So excited to be here. Before we get into specific cases, I just want to open up with a question for each of our panelists. Given that we just concluded another SCOTUS term, what are your biggest takeaways from this Supreme Court term, and where do you see the movement for LGBTQ legal rights and equality at this moment?
Ricardo, I can begin on that question, because the end of this very difficult Supreme Court term really brought my thinking back to GLAD's earliest transgender rights cases. Many cases that Jennifer brought early on, that Jennifer and I litigated together, that others here at GLAD litigated. We were bringing cases to establish legal protections for transgender people in a legal terrain where there was no established precedent for those rights. The law did not really grapple at that time with the reality of transgender people. I remember bringing a Title VII sex discrimination case on behalf of an employee of a New Hampshire college who was fired, right in a letter the university said, because she had disclosed being transgender. That was decades before the Bostock decision in 2020 vindicated that legal theory that we brought. I remember litigating the first and winning the first case in a state Supreme Court establishing the right of a transgender student to use the bathroom at school for girls as a transgender girl. I remember litigating against the Bush administration, against the Internal Revenue Service, which didn't recognize treatment for gender dysphoria as a medical condition for purposes of tax deduction under the Internal Revenue Code. And in all these situations, we had to think about what's the next building block case, what's the right legal theory, what's the right court, what's the right plaintiff. And that is sort of what our world is here at GLAD. So, in light of not only the Supreme Court term, but really what's gone on with this administration, there's no question we're facing the most difficult, challenging, hostile terrain we have, but the basic work that GLAD does remains the same, to figure out how to move forward, and we will.
And I would, in looking back at this term, what comes to my mind is religion, religion, and religion. I think the court is continuing its effort to deal with questions of free exercise from a perspective that sees religious people in this country as under attack. And so this term, I'm going to talk later about Mahmoud v. Taylor, which is a religion claim about parents objecting to books, LGBTQ-focused books in schools. But this year, the court also dealt with, in a unanimous a case about Catholic Charities in Wisconsin, challenging their exclusion from an exemption to the unemployment compensation tax. I think that decision was right, but it was, again, an interesting take on religion. And then we kind of dodged a bullet in the Oklahoma religious charter school case that you may have read about would have been the first chartered religious school funded solely by the government. And the Oklahoma Supreme Court said that that was unconstitutional. It went up to the Supreme Court, and then they split equally, which ended up affirming the Oklahoma Supreme Court. But that's because Justice Amy Coney Barrett could not participate. She had recused herself. And I think we know what her vote will be, and that this issue will be back to them in the not too distant future. And there are a couple other things that happened this year in terms of religion. And so that's what I think about in terms of the term. In terms of the LGBT movement, I really only know anything about, I guess, the legal movement. And what I'd like to say is that it is very strong. It's very energized. It's more resourced than it's ever been. Not as much as our opponents are resourced, but our legal movement is strong and ready for all the fights ahead.
Yeah, well, first, yeah, so great to be on this panel, and I love hearing Gary and Ben's reflections, because they really dovetail with the thoughts that I have in response to this term, which is, I think that there has been a popular attribution to the community, to the LGBTQ community, as being somehow dominant. And Ben, I was thinking as you were talking, kind of going back to that early work. And of course, it included the years of working towards marriage equality over that time as well. And then Gary kind of picking up that idea, particularly within the context of work to expand religious freedom, religious liberty, the suggestion that like LGBTQ people are dominant and have all this power and all this authority. And I think this term from the Supreme Court, with the many, many attacks on the LGBTQ community coming from the administration, combined with this really devastating loss in Scrimeti, and also, very disappointing outcome in Mahmoud, I think that I'm feeling that shift, right? There's no way to portray the LGBTQ community in some way as being anything other than, at the moment, attacked by states and the federal government and beyond. And so I feel like this is a really important moment, and in some ways a golden opportunity to win back public sympathy and support. And it is the importance, for me, the lesson and the takeaway with this consolidated 6-3 block at the Supreme Court, that we as a community have to continue to remind people about our humanity. And, I actually talked about this at the Spirit of Justice dinner just this past year, that, it's not about ideology. It's not about purity. It's about people. It's about the ways in which the laws, federal policy impact individual people's lives. And I think we have an opportunity at the moment to really try to diffuse some of the polarization that we're experiencing, continue to do what Ben was saying in terms of creating these important stepping stones that we have to navigate a path forward, but really focusing on the individual harms that people in the LGBTQ community are experiencing.
Thank you, everybody. Before we move to the next question that I have for you, Jennifer, I just want to plug, Jennifer has authored a series of blogs that are on our website that are really incredible and give you kind of a step-by-step journey of what we've been experiencing on the front lines, doing this work from the time that we started our strategy to file these challenges against these executive orders in the federal government. And I think they're just so poignant and so moving, and really focused on the humanity of our community, but also the work that we still need to do. So plugging it because I think it's important. I think they are a quick read, but also like profoundly, genuinely great read. So thank you. So back to you, Jennifer. I'm going to stay with you to talk more about what was probably the most anticipated LGBTQ ruling this term in Scrimeti. Can you explain what this case was about and what the court said?
Yeah, for sure. So yeah, all eyes have been on the Supreme Court for the opinion that it issued now, I guess it's a week and a half ago, in the Scrimeti case. So just to kind of lay some basic foundations, the case was a challenge to a Tennessee law that bans medical treatment for transgender adolescents. It was one of the first laws that was passed and what became a really sweeping wave of laws passed to ban medical care for transgender adolescents. And it was one of the earliest challenges to that law. I will say, you know, over half the country now has similar bans on medical care for transgender adolescents. And we've seen so much disinformation being, you know, propagated throughout media. And we've seen, unfortunately, really, you know, attacks on families with transgender kids and parents who have been supporting their transgender children. So this case was, you know, a very significant focus for the community. Now, the challenge to that Tennessee law was quite simple and straightforward. The ban, in the challenger's argument, was intended to cut off care for transgender minors. And in so doing, it classified people on the basis of transgender status and prohibited medications needed only by transgender people, in that context, transgender minors. And because of that, the argument was that the law also classifies on the basis of sex, for a very straightforward reason that the Supreme Court had already articulated in the Bostock case, which is that you can't classify on the basis of transgender status without also classifying groups on the basis of sex. And that was an important argument because it means, if the challengers had been successful, that the court applies heightened scrutiny, looks at a law very, very closely, and in ordinary circumstances, it would fail. It's not the opinion of the majority in that case. Rather, in a decision written by the Chief Justice, the court found that the Tennessee law, instead of classifying on the basis of transgender status, which seems so obvious, both from the language of the statute and what we knew was the motivation behind all this sweeping wave of legislation, rather the court said that the law classifies and regulates a medical condition, simply a regulation of medical care. And typically that would get very deferential review from the court. And that's what the court said in this context, was that it's perfectly permissible without really looking closely either at what the justifications were or the group that was harmed by the statute. Now, I want to say that that move by the court to say that the law has nothing to do with transgender people or with the sex of individuals who need that kind of medical care has been kind of characterized as a sleight of hand. And I think that's fair because it really ignores very basically both the statutory language and the way in which it operates. And I will say that even Justice Alito, in a concurrence, said that he was uneasy with that analysis. And why? It's because the prohibitions under the Tennessee law are triggered by, and I'll say this is a quote directly from the Tennessee law, a minor's intent to express a gender identity different from the minor's biological sex. Like, it's hard to see how that has anything not to do with transgender people and sex classification. So the bottom line is that the court said that a law regulating medical care for transgender minors gets the most deferential standard of constitutional scrutiny and survived in that case. I want to just say a couple of things that are really important, which is that obviously eyes were on this case because of the significance of the outcome for transgender people, but the other potential legal issue in that case was whether the court would apply heightened scrutiny to laws that create a transgender classification. And the court ducked that question. It didn't answer that question. So importantly, that remains an avenue for continued work, which is very important. There's a couple of other things that the court said, and that is that it preserved challenging laws that are rooted in animus. That legal doctrine has been very important for LGBTQ people. All of the work really that we've done, particularly in the Supreme Court. And it also left open the possibility that a law could be challenged if the challengers could show that regulating a medical condition is a pretext, basically, for regulating a particular group that's in fact that's impacted by the law. So the short answer is really devastating outcome, and I know we'll talk about the impact of the law, and in some other ways it is narrower, leaves open pathways for significant amount of work. But I think the reality is that we're also all kind of taking in what the broad impact is of the decision.
Yeah, thank you for all of that, Jennifer. I think just piggying back on how you ended there, I think it's important to acknowledge that people are really probably sitting with this still, and just processing what this means for everyone, because it was such a devastating ruling for our community, and particularly for trans young people and their families in Tennessee and other states where bans have already occurred. What can you share about how people and families are responding to this decision?
You know, as I said, and I mean, as you know, there's been a tremendous amount of heartbreak and loss in terms of the outcome of the decision. There are many families who have been having to navigate incredibly challenging terrain just to get the medical care that their kids need. And you know, as a parent myself, it is such a I mean, no parent would want to be in a position of having to think about moving from a community that they've lived in, many of them for decades, and where all of their support is, or being able to get the healthcare that their child needs. And what I've been so impressed by, Ricardo, though, is the ways in which communities have been pulling together to support one another, to really forge community around the challenges that people are facing, and to come up with strategies to build and move forward. And we know that there's a long road ahead to really reverse the devastating impacts, but that's what I'm seeing, is community being built around this, creative strategies. And it's just to say, like, it's Pride Month, and the visibility of the both outrage of the community, but also the coming together in response to this decision. It's really inspiring to me.
Yeah, underscore that, echo that 1,000%. I keep my eyes and my ears open to everything that organizers are doing all across this country, and it's been really incredibly heartening and moving to see people show up for each other, both at the legislature, but also just in gathering in community and pushing back. So more of that. Moving forward, what do you see as the next steps for protecting access to healthcare for transgender people and transgender rights more broadly, both in terms of legal strategy, but also policy advocacy and public education?
Yeah, well, I do want to say, Massachusetts and a number of other states across the country have passed SHIELD laws, and SHIELD laws are designed to ensure that in states that have passed them, there is an affirmative policy ensuring access to continued care and treatment for gender dysphoria, including for adolescents and adults as well. And really strengthening those laws has been so important to do everything that we can to ensure that there is continued access to care. But despite that, we have heard announcements nationwide of clinics shutting down. There are efforts both behind the scenes and in front of the scenes to try to keep that from happening. That's working both across the community of providers, but also working very closely with healthcare institutions that provide this care to hold people accountable to the continued responsibility to provide care, making sure that we're working closely, as I said, in the states where care is not prohibited, is really essential to continue to put community pressure on these institutions to make sure that they are open and accessible for LGBTQ people, and clearly including transgender adolescents. I want to say that at the end of the day, the Tennessee law at issue is a state statute, and state statutes that ban care are reversible. And that means that organizing in those states is really essential. And, we will absolutely and are absolutely seeing that build. And of course, it makes so much difference to have those strengthened coalitions accessible to work on a wide range of issues that are is impacting the LGBTQ community. So lots more work to come. There's just no doubt that, and kind of drawing again on what Ben said about the building the seeds that had to be planted to have decisions like Bostock emerge really decades later, is that these kinds of decisions are absolutely galvanizing, and they need to be galvanizing for the community. And I just want to say, I was looking, kind of thinking about my remarks today, looking back at reflection after the marriage equality decision in 2015 by one of, someone early on working on that issue. And they talked about, and, everybody on this call lived through this, but not everybody who's listening to this has necessarily lived through it. I mean, there were really dark times during the course of that work, and I'm thinking about the beginning when 2/3 of the country opposed marriage equality. Progressive political administrations opposed it as well. Just to name it, like the 2004 election of George Bush was publicly blamed on the marriage equality work. And I remember state after state passing like increasing levels of statutes prohibiting equality, and then constitutional amendments prohibiting equality, and courts like New York going against the work. So we've come from very dark times, and we do know how to do the work, and with the strength of the community, I really know that we will move forward, but clearly people are going to be and are being devastated in the meantime.
Thank you so much, Jennifer. Ben, I'm going to turn it over to you. There was a little good news this term when it comes to protecting access to preventative health care, including HIV preventative medicine. Could you please tell us a little bit about Kennedy v. Braidwood, that case, please?
Yes, so it is good to have one case that we can categorize as a win. And this case, Kennedy v. Braidwood, really hasn't received a lot of public attention because it involves sort of a wonky technical insurance issue under the Affordable Care Act. But the stakes of this case were really dramatic. So if this case had been a loss, not only would the decision have really undermined HIV prevention efforts nationally, but a loss in this case would likely have resulted in the deaths of tens of thousands of Americans. Okay, so that may seem a little dramatic, but that is really what was going on here. So just to then bring that into the weeds a little bit of the Affordable Care Act, when Congress passed the ACA, it wanted to address the problem of chronic disease in this country. The cost of chronic diseases like diabetes and cancer, heart disease, to individuals and the devastating impact on individuals, but also the cost to the public health system of our failure to prevent chronic diseases. And so it included within the Affordable Care Act a requirement that health insurers cover certain very effective preventive measures without any cost to the consumer. In other words, you don't have to pay a copay, it's not subject to your deductible, it's basically free. So this has become ingrained in American healthcare. People don't realize when they go for their colonoscopy, they're not paying anything. Okay? It's because of this provision in the Affordable Care Act. Importantly for our community, we obviously care about all preventive healthcare, but PrEP, HIV prevention medication, is one of the preventive services that is designated under this ACA provision as being so effective that it's included in among the 50 or 60 preventive services that have to be covered with no cost under health insurance plans. And importantly, it's not just the cost of the medication, it includes the cost of all the ancillary laboratory and monitoring services that people on PrEP need. And that cost is greater than the medication in most cases. So, and we know that when insurers impose cost sharing, use of the preventative measure goes down, right? It just stands to reason. Fewer people are going to take advantage of the intervention. And in this case, we'll get into a little bit of the history of the case, but basically some conservative businessmen in Texas challenged the constitutionality of this provision under the Affordable Care Act. It was, and their challenge was upheld in the federal district court in Texas and in the U.S. Court of Appeals for the Fifth Circuit, which is the most conservative circuit, as we all know, in the country. And then the case went up to the Supreme Court with first the Biden administration, defending the mandate, and people weren't sure what the Trump administration was going to do. And in fact, to our surprise, the Trump administration continued to defend this mandate, partly because it is so popular. And the result of this ruling last week was that by a vote of 6-3, with Justice Kavanaugh writing for the majority, the court upheld the constitutionality of the ACA's mandate for preventive services. So it is very good news. And it's one of those decisions that good news is almost no news in the country, but bad news on this case would have been huge news because of the tremendous disruption to the healthcare system and the devastating impact on people's health, and certainly for access to PrEP.
Thanks, Ben. You covered, I think, the majority of the second portion of the question, so I'm going to move to question 3. This is great.
Yeah.
While the ruling protected access to PrEP and other preventative care for now, there is still some risk from what might happen in the future, given the current political climate. Can you speak to us a little bit about that?
Yeah. Well, let me just say I will answer that, but I also just want to make sure people understand in terms of where we are with PrEP in this country, that this case began in 2022 as a challenge to PrEP, as an attack on PrEP. So it started with these conservative businessmen in Texas who actually objected to the requirement, the federal requirement that they cover PrEP, because they said that PrEP encourages homosexuality, promiscuity, prostitution, intravenous drug use, and a bunch of other things that they said violated their religious beliefs. And they prevailed on that issue. It's an argument that we think the court got completely wrong. But as the case went up on appeal, that the religious component of the case dropped out. It was not appealed. And what went up on appeal was the broader attack on the preventive services mandate, which covers 50 or 60 preventive health services. What happened at the court was, and this is a little bit of the sort of technical constitutional issue, was the challenge to the mandate is that under the ACA, it's a body within the Public Health Service called the U.S. Preventive Services Task Force that makes these designations of recommended services. And what the challengers said was these volunteer scientific experts are actually making decisions that are so important because now they're linked to the requirements of what insurance plans must cover, and they're not supervised or directed by any presidential nominee. They should have been nominated by the president and confirmed by the Senate. And they weren't. So if the court had upheld that argument of the challengers, it would have gutted all of these preventive services mandates. The flip side of that is the way the court saved the mandate was that they had to rule that these members of the task force were not principal officers who had to be appointed by the president, but they had to do that by interpreting the statutes in such a way that the members of the task force were supervised and directed by somebody who was appointed by the president. And that is none other than the Secretary of Health and Human Services, who we all know is none other than RFK Jr. Okay? So under this decision now, the court has made clear that the secretary has the power to remove the members of the task force, to appoint them, to remove them, to block their recommendations, to delay their recommendations indefinitely, to reverse their recommendations. And so we now have all these preventative services, including PrEP, that are subject to much greater political control in this particular administration. And so it's good news that the mandate was saved, but we have to be really vigilant about what's ahead.
So what is GLAD Law thinking about in terms of addressing those vulnerabilities, and what can states do now?
Yeah, well, what we are thinking around PrEP is very similar to what we're thinking a lot about healthcare for transgender people, which is we need states to to create the protections on the state level. We're not in a world right now where we can simply rely on the federal government or the rulings of federal appellate courts necessarily to ensure access to medical care for our community. So specifically around PrEP, there are issues not only related to ensuring that the prohibition on cost sharing remains in effect, but one of the big issues around PrEP is the advent of long-acting injectable medication. So now PrEP started as a daily pill. We now have an injectable. The latest one that was just approved by the FDA is a 6-month injectable. So people who are not necessarily on PrEP, who should be, but may have trouble, say, adhering to a daily medication regimen, can get a shot just twice a year and be fully protected from HIV. But insurers are going to put up a lot of roadblocks, including requiring prior authorization, meaning that the insurer has to review and approve the recommended therapy. So we want to pass state laws that we're working on in Massachusetts, in Maine, and Rhode Island. We worked on it in other states that remove all these insurance barriers at the state level and actually codify the existing federal protections as well.
Thank you, Ben. I'm going to turn it over to you, Gary, to talk about our final case, Mahmoud v. Taylor. Could you share a little bit more about this case with us, please?
Sure. This case arose in Montgomery County, Maryland. I was kind of startled. It's one of the largest school systems in the country. It has a $3 billion budget. It has over 160,000 students in over 210 schools. And it is also one of the most religiously diverse countries in the country. And leading up to 2022, the school district started an effort to diversify their language arts curriculum. They had a sense that they were not quite reaching all the vast array of the community in Montgomery County, and in this particular case, the LGBT community. And so they went through a process and they identified a series of books for the language art curriculum. And that curriculum now has somewhere between 200 and 300 books. And they approved 13 books, LGBTQ themed, for grades K through 12. 7 of those books are for K through 5, and they became the focus of this litigation. And in the course of the litigation, 2 of the books were removed from the curriculum. So it's about 4 books, K through 5. And when they were adopted, Montgomery County has an incredible guidance on religious diversity, and they allow opt-outs for many, many things, and they make accommodations. They have so many different religious holidays being celebrated that they have guidance on what days to avoid having tests on because of the possible absence of a significant number of students because of those religious holidays. And initially, they provided an opt-out for these books. And then after some experience in the first year, they decided that it had become administratively impossible to manage all of the opt-out requests. And so they simply said, there will be no further opt-outs for these books. And that led to this litigation by 3 families who have kids in the schools who actually, each of them actually removed the kids from the schools and put them in private schools, which they said at great financial expense that they really couldn't afford, but they weren't going to keep their kids in a situation where they couldn't control their access, their exposure to these books. So that's where how the litigation started.
So what did the court say?
Well, I mean, bottom line, the court said that they agreed with the parents. The lower courts had not agreed with the parents, and for good reason I'll go on to talk about. But the Supreme Court said that the parents were entitled to, they'd established a burden on their free exercise of religion, and that's the first test under the free exercise clause is the government substantially burdening your exercise of your religion. And the Supreme Court said, yes, this is a substantial burden on their free exercise of their right to control the religious upbringing of their children. And therefore, they have the right to notice when these books are going to be used in instruction and the option to opt their children out of that instruction. And it is that specific. The parents did not say they wanted the books out of the school. They said they were fine with them being in the library, being in the classroom, being read by other students, being available for any student to read, but they objected to them being read or discussed or talked about in classroom instruction. And that's what has been enjoined for the school district, what they cannot do.
The court has looked before at the question of whether something simply being part of the public school curriculum burdens a parent's religious belief. Can you talk about some of that history and how this ruling is a departure from that?
Yeah, and I think that's that's the crux of this case, and it's the interesting part of this case, and it tells you a lot about where this court is going. Because as Justice Sotomayor said in dissent, we have always said that exposure to ideas does not violate the free exercise clause. The free exercise clause is about coercion, making you do something contrary to your religious beliefs, or to disown your religious beliefs, or to have to disown them in order to get some benefit. And what the majority said here, they did an interesting twist. Well, let me say, we have historically always followed through on that exposure point, because in the last, say, 30, 40 years, parents have objected to women's role being in the classroom, evolution, wizards like Harry Potter books, drug prevention, yoga,
Oh,
and
no.
co-ed physical education. And parents have challenged these as violating their religious beliefs. And the Supreme Court and the lower courts have always said, what? That's not violating your rights just to be exposed to these things. We're not making you change your views, profess any views. And as what Justice Sotomayor said, well, let's go back to a fundamental case in 1943, West Virginia versus Barnett, when Jehovah's Witnesses, who will not pledge to a pagan image, their kids refused to pronounce and pledge and salute to the Pledge of Allegiance. And the Supreme Court said, well, that's right. You can't coerce our children to do something like that. It's absolutely contrary to their religious beliefs. But at the same time, the court said there's nothing wrong with them having to be in class while the pledge takes place. The fact that they're exposed to the pledge is not a violation of their fundamental rights. And so what Justice Alito did in the majority here is he turned that exposure analysis into a threat analysis. And he said, this stuff is threatening to the parents' right to control the religious education of their children. And he went back to a case that even most everybody in America has probably heard about, the Yoder case, in which the Amish challenged the obligation under the compulsory education law to send their kids to high school. They believed that education, public education for their kids had to end at elementary school because their adolescent kids had to be in the community, working in the community, learning the Amish way of life as young adults and into adulthood. And the Supreme Court said that's right, because they said that making them go to high school threatened the very existence of the Amish religion. And so over the years, in the last 50 years or 60 years since that decision, the courts have always said that the Yoder decision was kind of a one-off. It was a unique situation about a threat to the existential threat to a religion. Well, what Justice Alito says in this case, oh, no, no, no. Yoder means a lot more than that. It means any threat that undermines parents' ability to control a religious upbringing violates the Constitution potentially. And so suddenly we've turned the Amish situation about their kids being kept from living their way of life to being exposed to Uncle Billy's wedding book. You know, they've taken what was really a threat and now created a million new threats that parents are going to have a right to sue over. And I mean, that's a big deal. And Justice Sotomayor in her dissent explains all the ways in which this upends how we've always understood how the schools work. Schools are trying to educate everybody and expose them to everything, and we've left it in the control of local school boards to make those democratic decisions. You know, they're elected. 3 of the 7 Montgomery County School Board members were voted out of office. As I said, 2 of those 7 books were taken out of the curriculum. There is a procedure in every school district to challenge a book that's in the school system, to put it before the public to say, we want to get rid of this book. And this has overlooked all of this, which the Supreme Court has praised for decades, and now given a subset, as Justice Sotomayor again said, a subset of parents a veto power over curriculum. And anyway.
No, I think that's really good. And you answered the question that I was going to ask next. So I'm going to go to the following one, which is, what would you say to parents, educators, and others that want to protect access to a variety of stories about different kinds of people in our public schools?
Well, but let me go back a little bit to impact too, because I think Jennifer and I were talking about this earlier today. The practical impacts of this. You know, schools, no matter how much money they have, I can't imagine how much Montgomery County paid their lawyers to do this case. You know, millions of dollars. They don't want to be spending money on that. Small school districts can't afford to do that. So I suspect that every school district in the country either has started or is going to start very soon talking about, what are we going to do about our curriculum? Do we have to remove all the LGBT books because we can't manage all those opt-outs? We can't afford the litigation. And I think schools are going to start making just what they think of as practical decisions to remove lots of things from the curriculum, or at least they're going to be struggling with what to do. And I think what we all have to do and what parents have to do is, one, get involved in school board matters and be there when these decisions are made, and push for the fact that we have to have a curriculum that looks like the community, that's an important value. And that, as Jennifer was saying to me this morning, we have to be working for middle ground compromises, things that can work, that people can agree on. Everybody can agree on, because I don't think most people across the board are ill-willed about this, you know. But I mean, to be honest, I mean, we have these books in Montgomery County have been looked at by a lot of people and a lot of our fans. And you might look at a couple of those books and say, really? What is that doing in a first grade curriculum? You know, I mean, we have to find ways that are going to enter into conversation with everybody to find ways to make this work.
Thank you, Gary. We are 13 minutes away from the end, but I am still going to pose the next 2 questions. I just wanted to open it up, number one, to all 3 of you to add anything else that you are paying close attention to coming out of the Supreme Court term. Are there decisions or trends that you think are important that we should uplift to folks who are tuning in today?
I'm happy to jump in. I know a lot of folks have been following the case of Trump versus CASA, which is a challenge to one of the first executive orders from this administration that seeks to alter birthright citizenship for people born in the United States. And even though the court didn't address the merits question, and that's going to be for another day, I pulled out my pocket constitution because I feel like I need to do that frequently to remind myself and urge anyone else to look at the 14th Amendment, Section 1, which guarantees birthright citizenship. So just to say, like, on the merits question, it's a really big issue that has gone up to the Supreme Court. It was not the issue that was decided this term about whether the administration can limit that right. But what the Supreme Court took up was this question about the relief that federal courts can issue in cases, because the lower court had issued an injunction that that granted what is characterized as universal relief, which basically means that anybody that's impacted by the challenge can get the relief that is secured by the individuals in those cases. And the court issued a decision that is really very impactful for lawyers that are working on challenges to laws or policies that are unconstitutional, because what the court said is that the court doesn't largely have the relief to issue those universal injunctions. Not never, but often that is not the case. It left open the possibility of pursuing that kind of widespread relief in the context of class actions, which is, now going to be a really potentially important source of litigation going forward. And also said that there's this other very technical federal law, the Administrative Procedures Act, for which there could also potentially be broad injunctions issued. But it also sent back down to the court an important question, which is what the challengers have to show to get broad relief, where an individual needs that universal, or an individual or a government entity, in this case, the states that brought a challenge, to get the relief that is needed for the challengers to the case. And so it's kind of a long way to say that there's a really important tool out there that lawyers have used to be able to challenge unconstitutional law or policy that the Supreme Court has narrowed. And, Gary shared with me earlier, because I know that he tracks this very closely, and Gary, you should add in anything more you want to put a point on this, but we don't know. Like, we're going to find out pretty quickly, I guess, in maybe the next 30 days, what the lower courts think about the meaning of the CASA decision, but it's certainly going to impact our work going forward.
Yeah. And I just add that, there were a lot of people who wanted this ruling 8 years ago. I mean, the Biden administration was subjected to a boatload of universal injunctions that we all thought were wrong and inappropriate. So there's a kernel here of something that is probably okay. The context in which it's happened really looks bad. But the court may be, just finding its way on something that it needed to address a decade ago.
Can I just add in one quick thing?
Oh, yeah.
Because Justice Sotomayor in dissent pointed out in this context that the probably the most concerning part of the outcome of this decision is that it authorized what she characterized as the possibility of gamesmanship by the federal government to avoid important constitutional questions even getting up to the Supreme Court, because depending on how this case comes out on the remand, it also means that people have to bring kind of one-off challenges. And if they win, Justice Department can just sit back and not appeal the issue. And so that's, potentially quite consequential.
Yeah, I mean, I don't know if people saw, but now the government has been losing in these birthright citizenship cases in 3 different courts. They go up on appeal to the courts of appeals and say the government loses there. They can choose not to appeal to the Supreme Court and let that be. And now the Solicitor General in oral argument told the Supreme Court that, no, if that happens, we will appeal to you, the Supreme Court. And there's word on the street that Sauer's job is at risk for having said that to the Supreme Court.
Which would be one way to not have to bring it up. Yeah.
Anything else to add here, folks, before the next question? All right. Go ahead, Gary.
I mean, do you want us to talk about, are you on to who else has something about the next term or?
Yeah.
And I can speak to, continuing with the religion flavor of my things I'm watching. We thought that challenges to the bans on conversion therapy were over. They've been challenged. They've been mostly, the laws have been mostly upheld. And then at the end of 2023, a case was at the Supreme Court out of California, and they decided not to take review. And so it seemed like maybe that issue was over. And then out of the blue, less than a year and a half later, the very same court has now agreed to hear a challenge to Colorado's ban on conversion therapy. What that means is that 4 justices voted yes to hear the case when it didn't seem like a year and a half ago with the same justices, no change in the court. Either they had the 4 votes and didn't think they could get a 5th, or they didn't have 4 votes and now they do. And what this case is, it's a challenge it's interesting. It was brought by a Christian counsel. And what they're saying is that when we deal with speech therapy, talk therapy, that is free speech protected by the Constitution. But she brought both a free speech claim and a free exercise claim. She lost them both. And now they've gone to the Supreme Court just on the First Amendment claim. And this is a repeat of what the plaintiffs did in the 303 Creative case, which was the Colorado wedding web designer. And she lost on First Amendment free speech and First Amendment free exercise. And then they only got a First Amendment free speech claim to the US Supreme Court, I think, because they think they're on stronger ground here. But in any event, what they're saying is that this is censoring speech between a counselor and a client based upon viewpoint. So we're going to see this as a free speech case next term, but it's infused with religion. And I don't know, it's hard to be optimistic how this is going to come out. Though interesting, if you put I'd love to know what Jennifer thinks of this, because if you put a Scarametti lens on it and you think about this as treatment, then after they gave all this deference to the Tennessee legislature about making decisions about what's for the good of youth and important for protecting our youth, why can't the Colorado legislature protect our youth by keeping them from conversion therapy?
Yeah, well, I want to pick up on that, Gary, because I mean, yes, there is technically only a First Amendment issue in the case, but having seen the way in which it's been briefed by those that are challenging the law, I think it's so important for everyone in the community to know what's at the heart of the kind of public discussion of this case is the realness and the legitimacy of being LGBTQ and whether or not a person's sexual orientation or transgender status can be changed. Not court of the legal issue, although, at some point, depending on the level of scrutiny that the court applies, that's what it has to look at is, what is the body of science that shows, which is well established, that conversion therapy is harmful. And there are, too many survivors of that who are around to talk about the devastating harms, but what it means in terms of the public discussion. And I think this is kind of the follow on to Scarametti, is those who would like to see, the end of support for LGBTQ people, but certainly LGBTQ young people. And I think it's so important for us to see the connections across the work that's coming at us and to understand, like, whatever the legal framework that is, which is the First Amendment that's going up to the court. And I agree with you, Gary, like, how can at the same time the court say that states can regulate medical care and healthcare and then not allow Colorado to prohibit these rejected practices that have deep and devastating harms on people? Totally, that should be the consistent, outcome in the case. But in terms of the public conversation around the case, I just think it's so important for everyone to understand the stakes of the Childs case and what we're going to be hearing over the course of, the next many months and over the next term leading up to a decision in that case.
Yeah, because they're not just saying anymore that transgender people don't really exist. They're really saying that gay people don't really exist either.
Yeah, there's sexual orientation, transgender status are not stable or changeable. And yeah, and they've got a moral position out there as well that is in opposition to that.
So we have a couple minutes left, and I think maybe we can go over a minute, but then we have to really switch gears and sign off for tonight. This is undeniably a really hard time for very many people. And one of the things that keeps me going, at least, is number one, working with y'all and finding innovative ways to really tackle these issues right now and still be on the offensive and pursuit of the liberation for queer people. So my final question to y'all is, where do you get hope? Where do you find it these days?
Anybody want to start or?
No, Ben, go.
Go. All right. It's always such an interesting question to think about where we find solace and hope in the most difficult times. And for me, I always go back to the early years of my coming out, which was 1979, and it was such a void of recognition of sort of that LGBT and LGBT people existed. And it was a time in which people thought being gay or, being gay was still an abnormality, that it could be changed, that it could be changed and should be changed. And what really gives me hope is not only the tremendous power of our community, but when I came out, very few people in America knew a gay person. And everybody that I came out to said I was the first person they knew. That changed over a couple of decades, in part because of the AIDS epidemic, where people became really aware of the lives of gay people. And when that happened, we began to see more rights, more acceptance, including marriage, which wouldn't have happened without that visibility. And I do hope that this moment, which is such a horrific time to be trans in America, leads to greater visibility, more people knowing transgender people, because I believe that once people know who we are, that things will change and understanding will lead to better protections in the law.
Amen.
Amen. Yeah. I mean, I just echo everything that Ben said. I could, not say it more articulately. And, like, the community absolutely gives me hope, and the creativity and the moxie and the boldness and the courage of people doing all kinds of things to provide support for one another, but also coming up with creative solutions every time there is, some, whether it's a decision from a court or a harsh policy that issues from the administration. I'm like amazed at the creativity that people come up with to support one another and to just like keep building and moving forward. So also I want to acknowledge though, like, it is, it's demoralizing. It's super demoralizing. And I'll, just to, be candid about where I'm at, it is so hard and overwhelming. And what we are facing is, of course, there's like historical perspectives to bring for it, but it's bad and it's exhausting. And we need each other desperately to be able to continue to do this work. And so I do hold on to hope. And I also just want to own the demoralizing, exhausting parts of the work. And there's some days where I think, I don't know how we're going to take on what's coming next. And sometimes I'm the one that steps back and someone else steps up and is like, comes up with a really creative, interesting idea. And I'm like, awesome. Now I feel a little more re-energized, but taking that pause can be really important too. So
That's real.
1000%. Well said. Gary, anything to add before we close?
Nope, nothing from me.
All right. Thanks everybody for joining us. Just a reminder that as I mentioned earlier, we may not get to the questions around passport. So you do have a very specific question, please email or call Glad Law Answers. If you go to our website under Your Rights, there should be a page that is dedicated to Glad Law Answers with all the information that you need to reach out to us. Again, thank you for joining us and reach out anytime.